Howdy, Eddie.
Evening, how are you?
I'm doing pretty good, sir. How about yourself?
All right. Can you hear me all right?
I can, loud and clear. This first class of the month, correct?
Yes.
Okay, excellent. Do you have video presentation you're going to be doing, or what's the scope tonight?
Well, one of the things we're going to go over tonight for a little bit is we're still working on cross-examination stuff and all that. But for the most part, I want to see if there's been any updates in anybody's cases. I want to try to get Jane to come on here for a little bit and explain the outcome of her case and everything that I was helping her with. And then once that's done, we'll get into something else.
Okay. Well, Tonight, I need a few minutes once we get started. I'll prepare while you're doing some other things, but I have a couple questions relative to the definition of person in two different areas of the Texas State Code.
Okay.
And so I'll get them where I can post them to the chat, and then I'll get you to look at them.
You can ask me about them. I mean, depending upon where you're looking and in what code, the definition of person varies greatly.
Yes, I've found that from two different.
But the most important thing to remember about it is that the one in Chapter 311 is controlling if there is no definition provided locally.
Okay. I believe the two codes that I'm looking in, so one's going to be in the Texas Business and Commerce Code. There's a definition of person there.
Okay, which applies why?
Because of this Texas Deceptive Trade Practices Act lawsuit that I've got against me for land sale that I made. I've kind of started linking you to it. So that's what the DTPTA Act is under Business and Commerce Code. And then the other one is relevant to local government code. And that has to do with the subdivision I did on the property that seems to be the problem, that the state says that the land can't be developed because of the subdivide that I did. And it had an interesting reading to it in definitions. This is Texas Government Code 311.005, general definition.
311.005 says they are fictional entities unless there's a local definition that says otherwise. That's the definition I'm talking about.
Okay,
that one controls over every code in Texas, unless there is a local definition that relates to the specific statutes under which you're operating.
What about number 13 on that code that says, because that says specifically for person, like you said, it says fictional entities, right there. Person includes includes being the keyword here, corporation, organization, government, governmental subdivision, agency, business, trust, estate. So all fictional stuff, right?
Yes, but includes limits that list to like things. So they must be creatures of law in order to be applicable to the term person as defined by Chapter 311.
Okay, what
now,
about number
you will
13?
find in the local statutes, the way they try to gum that up is this. They will include a list of fictional entities, but the very first thing there will be individual.
Right, and that's the Texas Business and Commerce Code.
Right. Now, here's the thing. How do you list a thing that use the word includes to encompass the definition of individual, which under the criminal code is a person who is born and is alive, with a list of fictional legal entities? How do you reconcile the two, since includes requires everything that follows to be of the same type or class?
Right.
How do you reconcile those two things?
You don't.
Yes, you do. There's only one way to reconcile those two things.
Okay.
And that is the individual must be acting as a representative in lieu of one of those fictional entities that are in that list. That's the only way you can harmonize a living, breathing individual with a fictional individual as defined under the term person.
So that plays into an individual one of somebody that is part of a corporation or part of a...
that is acting as a representative of or on the behalf of. For instance, let's say you are the owner of a trucking company that's incorporated, right?
Yep.
Okay? You are an individual. They can charge you with violating the traffic law, right?
Yes.
Okay. That would be a different thing than suing your trucking company. They can sue you as the individual who is the owner of the trucking company because you're acting as its representative. Okay? Unless the corporate veil protects you, depending upon how you got it set up, et cetera, et cetera. You understand what I'm saying?
Right. Yeah. Well,
but the point is that the limiting language of includes is what makes that a requirement.
Well, that's where my second question in relevance to that comes into, and this is also in 311.005 general, is number 13, where they say includes and including are terms of enlargement, not of limitation or exclusion. That's
right. But the enlargement is limited in how it can be done.
Okay.
For instance, let's say, and I wrote 2 different articles about this on my legal blog. Okay.
Those are on the website for your.
They're on the legal blog under the use of includes and including. Okay. But the way the expansion thing works is this. Let's say you are talking that the statute defines citrus fruits, and it says the term fruits includes lemons, limes, and tangerines.
Yep.
Okay. What do all those 3 things have in common?
They're all citrus.
They're all citrus. But because the term includes is used to make that list, how can you then expand that list?
You could say grapefruit are part of it.
Correct. You can only expand it by applying it to other things that fall within the citrus category.
Right, but you couldn't say an apple or a banana or
correct.
Grape.
You could not put non-citrus fruits into the category of fruits because includes limited it to citrus fruits.
And is there a term within statutory construction that relates to that? Like there's ejusdem generis that ties to things.
Ejusdem generis is exactly that.
It is ejusdem generis.
Yes, like things.
Okay.
That's a legal maxim.
Excellent. In any of your documents that are available.
And here, there's actually 2. There's ejusdem generis and there's est estudio unius est exclusio alterius.
Yes.
The inclusion of one thing is the exclusion of others.
Got it. So in that 311 where it says all fictional things, it could only be other fictional things that are there as far as persons, not a living, breathing man.
No, it would have to be a living, breathing man acting as a representative of.
Right. So if I'm not a representative of any of those things and never have been, then that term person would not be relevant to describing me.
Not unless they can find a way to defeat ejusdem generis.
Okay.
And that there's also Supreme Court case law on that about the use of includes and including.
Okay.
There's shitloads of it.
Is that outlined in your articles on that as well?
I believe so.
Okay.
I believe so.
I will look over those.
It's been a long time. I mean, a real long time since I've read them, but I think so.
Okay. And then I had emailed you this week and just asked, I had heard something talk or whatever about, and I thought you might have mentioned having it. It's the Texas state annotated statutes, and the
annotated statutes contain some of the case law, or at least the controlling case law in most cases. Not all cases, but in most cases, that define the meaning of that particular statute.
Okay. So do you personally have access to the annotated statute?
No. The annotated statutes are only found on specialized sites like LexisNexis or law or legal
Westlaw.
books.
Yeah.
So you can get actual legal reference books that have annotated case law in them, but you're talking multi-hundred to thousands of dollars per book.
To
get them.
Yeah. So I was trying to see if I could find access somewhere through to that to do some background research on cases that have been defense cases against this DPTA suit. Type deal. This is what got me into your class in the first place, was getting nailed by the attorneys and all that over this suit last year by the other buyer. I subdivided my 12 acres into 2 6-acre parcels, basically. Sold one to a neighbor, sold the other to another guy that was going to build a business on it. And the county had tried to stop me from subdividing initially. And I said, okay, by what code are you stopping me from subdividing? Because they just flat out said, you can't do it. And I said, well, where does it say that? And they said, we told you no. That's what it says. So I wrote to the county commissioner, the governor of Texas, the attorney general, and a couple other folks, and said, "Hey, this is how your employees are acting. I want to know what the law is. This isn't how the law works. Is you just tell me I told you so. It's got to be listed somewhere." So then it forced them to come back and tell me what code they were using. Then I went through that and I found exceptions to it. And so I said, "What about this exception?" And all of a sudden they gave me the ability to subdivide my land, until after the fact that it sold, and both of the people that bought defaulted on the loans. And now the county's coming back and basically saying, "Oh, well, it was an illegal subdivision, so nobody can build anything on it without proper platting. And the only way to plat it is to rejoin the two parcels." Well, a bank owns one of the parcels, and they're getting ready to foreclose on it. Not on me, on one of the buyers. And right. They've got, the buyer has me and the bank first listed as defendants on this deceptive trade practices suit, basically saying I tricked them into buying my land from me. I told them that they could do all these things on it or whatever, when I did nothing of the sort. Actually, I told them all I didn't pull permits to build anything on this land. So if you have any thoughts of what you want to do with it, you better go check it out first and make sure you're not going to have a problem with it, because I don't believe that those codes apply to me in the first place, and therefore I never asked for permission to do what I wanted to do on my own land. I bought in unincorporated area, and I bought on land that had no exceptions to the deeding on the property, specifically for that reason. So the fights with the county, and I'll get into it a bit more later, but one thing I did find in the code is that by the county recorder recording those two deeds for the subdivision, it flat out said that she's to not do that if it requires municipalities' approval for it. Otherwise, that they're not supposed to do it. And the county recorder did record both the deeds for the split and the platting. So it's already the county on both sides. The county is saying it's a problem, but the county already accepted that as legal subdivisions by recording the two deeds. So they're going to have trouble harmonizing that, I think. Well,
that's not necessarily the case, because they can always try to say that you defrauded the county with the paperwork you filed. Yeah. So never say that because they accepted it, it's good. Okay? Okay. Because they can always try to flip that script and make the allegation that you committed fraud by submitting the paperwork in the first place.
Right.
All right. So okay. Now let me ask you this question. Mm-hmm. Where you live at now, do you have access to a university or a public law library?
Nothing close to me.
You don't have a large public library that's got a law section in it?
I do not.
Where you are, or a university?
I'm out in the sticks, Eddie. I'm in a town with
define sticks.
I'm near a town with less than 1,000 population.
Okay, and the closest city that would have something like that?
About 2.5, 3 hours away from me.
Okay, well, that might be problematic. What you may want to do is see if there is one that you can get a membership to, that they will allow you to remotely access their book repositories, their online research, et cetera, while you carry an active membership card with them anyway, because most of those have computer systems with LexisNexis accounts already built onto them.
Does the Texas Law Library have that built in?
Yeah, the one in Austin does. Okay. And most university law libraries have them.
Okay.
If there's a university where you can get a law degree, they will have a law library. If they have a law library, they will almost certainly have Lexis and Westlaw accounts.
Okay.
And any student or member of the public that's allowed access to that portion of the library can access those and use them free of charge.
Okay.
Now, printing costs money.
Right.
But you can always dump things to a PDF and email it to yourself from that station. So you don't necessarily have to print it out at the library.
Okay. Makes sense.
That's assuming that the law library that you're in doesn't have things like Gmail or Yahoo or things like that locked down where you cannot access them from that computer. Because some of them do, so they can't get virus infected by somebody checking their email from them.
Yeah, that makes sense. I did have access to the Texas Law Library. It expired. I need to do it again, but I had to use a VPN that showed me as being in Texas at the time I did it. They've got it controlled that
and you
way.
may have to do that. Now, the other thing is you can also generate or print them to PDF and download them to a USB drive.
Yes.
Okay. So if you're using a VPN, depending upon how you're accessing things, you might be able to do that. I can't say for sure you will, but you might.
Okay. Yeah, the foreclosure, there was like a foreclosure manual I was going through when I was doing my own foreclosure on the property that I owner financed. And I was not able to download the one from the law library. Just I was able to view it. I checked it out. I could view it, but I couldn't. It was set up so that I couldn't save anything off of it. But I found previous year's editions that people had posted, and like Scribe or something like that, that I was able to download and use to just kind of get the basic idea of what I needed to be doing to do my foreclosure.
Okay.
All good information. Thank you.
Yep.
And that's good to know too. Don't bring up that they already approved it by the clerk doing it, because then they can turn around and say, well, I defrauded them into doing it.
Well,
which could cause
it wouldn't be fraud. They'd try to charge you with falsifying a government document. That's way worse.
Okay.
So be aware that's something they could very well try to do.
Well, they might try to do that anyway, though, too, right?
They very well could. If they think that they're losing, they may try to do anything they possibly can.
Yeah.
All right, everybody check the chat, especially you, Helen. There's a document in there that you need to be aware of on how to challenge a charging instrument. And this one goes to Texas, but it would work pretty much the same anywhere, I would think. When the charging instrument alleges elements that the offense itself does not codify.
I'm not signed in on the chat on my computer. I'm going to do that real quick, Eddie.
Well, it's in Zoom.
Right, but
it's in the Zoom chat. If you've got the Zoom, you don't have Zoom open?
I've got it on my phone, but I can't download the files on my phone. So I'm doing real quick. I'll be in there in 30 seconds with my computer.
All right. Well, I have to resubmit it again because it won't appear to you since you weren't logged in from there.
Exactly. Here's first class of the month. Usually that's why I'm signing in on 2 accounts. My computer just to open link. Come on. What is it that you're going to upload?
It's a document explaining how to deal with you're in, right?
All right.
Do you see it in the chat?
Okay, I'll turn off the microphone. Using invalid offense?
Yes.
All right.
Using invalid offense elements and charging instrument to overturn on appeal. It basically explains how you use the appeal process to invalidate the charging. We object to the defect in the charging instrument. The trial court ignores us. So we use that on appeal. And it tells you how to do that. That the trial court lacked jurisdiction in the first place to even try you because we challenged the defect in the charging instrument and the court ignored it.
Excellent.
But now that relates to a charging instrument for a criminal case, not for a complaint in a civil case.
Right. That for a traffic, like the traffic citation, even though they're trying to make it into quasi, still because it's tried under criminal code, an infraction or a violation is a offense under the criminal code, violation of a statute, so it would apply to that in my
If they're attempting to use the criminal rules of procedure and process to prosecute the offense, then they can't say it's administrative and they can't say it's civil. Okay.
Got it.
Now they try, like here in Texas, they've carved out a special set of rules for those types of cases. But where those special rules are deficient or non-existent, they must revert back to the other criminal rules of procedure to cover any area that their carve-outs don't deal with. Okay. So where Chapter 45A doesn't specify something that has to be done in a criminal case, they have to find where the rest of the Code of Criminal Procedure does specify how to handle that, and that's what they have to do.
Now, Eddie, this is at trial, you say, that we need to do this?
No. This tells you what this is on the appeal. We have to object. Remember that we have to object to defects in the charging instrument before there's a trial. No later than 1 day prior to the trial on the merits, right?
Right.
Okay.
Which we did already challenged that.
I know that.
Yeah.
And the court overruled and ignored it.
Mm-hmm.
Right.
exactly.
But on appeal, you're going to assert that this was not simply an abuse of discretion. It was a deprivation of jurisdiction to the trial court in the first place. They had no
Right.
jurisdiction to try the case. The defect was obvious on its face, and the court chose to ignore it and proceed.
That's true.
Okay? So, what that means is that if the appellate court agrees with you that there is a defect in the charging instrument, now you get to sue the fuck out of the judge too.
Oh, yeah.
Because a judge acting absent all jurisdiction has no judicial immunity to hide behind.
Yep.
No, nothing. But good luck getting the appellate court to do the same and actually follow through.
Well, that's why you keep appealing it all the way up.
I think that's
the
what I'm going to
appeals
have to
courts,
do.
especially the Third Court of Appeals, is manned by a bunch of fucking morons, which I've proven time and time again. They have no ability at all to read and comprehend the law. Absolutely none. So if your case goes in front of the Third Court of Appeals, you are going to have to appeal it to the Court of Criminal Appeals. No ifs, ands, or buts. Because they will not do their job. They will not do any kind of actual work. And they damn sure won't actually read and understand the law. They've proven they are incapable of that time and time again. They are completely incapable of that.
Yeah, as so is these damn statutory and municipal courts. They're just as dumb as
they just
rock.
don't give a shit because all they're after is the money. And if you fail to perfect your appeal or win your appeal, they get it. That's all they care about. Justice doesn't even come into the fucking picture.
No, justice isn't there. It's all about conviction. They don't give a damn about anything.
And therein lies the problem.
And it's like you're in a fucking meat chute when you're in there.
Well,
let's be honest.
You know why I chose the analogy that I chose, because that's how they're treating us. So it's time to learn how to treat them that way. They want to send you to a meat processing plant called their municipal and JP court. Well, it's time to show them what happens when they introduce a fighting bull into one of those arenas. No bull that's ever gone through a rodeo or a bullfight that managed to survive every one of them by running down the matador, they're not going to go through a meatpacking plant peacefully, guaranteed.
I feel like I'll just get railroaded all the way up until I hit somebody that's actually going to pay attention.
That's entirely possible, and you have to accept that's a possibility.
Yeah, I've come to realize that is more than likely the possibility is basically what they're going to do. But at the same time, I also am optimistic that everything I go through now is going to be hell on them later.
How's that?
Well, because there's somebody actually up above is actually paying attention to anything that we've argued, and they actually start looking at it and say, well, I'll be damned, this is bullshit, and they agree with me, and then I get to go back and sue their ass, and they have to go back to federal court and explain their stupidity. It's too late for them by that point. You know, it'll all be exposed.
Yeah, we might get lucky and get somebody like in those audit the court videos we've been watching where the judge is actually paying attention and
yeah, exactly. Oh. But it's Texas. I mean, it's few and far between, but there is a possibility that somebody will pay attention and say, what the hell is this? Why did you go through all this? Why are you spending all this money? No, this isn't right. We need to remedy this. And, you know, I'm optimistic in that part, but I feel like I'm going to have to go through hell to get there.
That plays into the question that I had for Eddie as well, relative completely to what you're speaking to, is you did at some point see justice in some of the cases that you've dealt with going up into appeals. Is that correct, Eddie?
Oh, yeah. We've won lots and lots of cases. In fact, I mean, like I told the class once before, a good example of one that we won that I actually went to court and watched them give her the dismissal order was Marnie Martinet's road rage case in the Austin Municipal Court. They tried to charge her with road rage when some teenage illegal alien and his girlfriends in his souped up pickup truck drove across the front of her Mazda and busted the axle on her car at a light. He was in the left lane. She was on the inside right lane. And he tried to make a right-hand turn and drove across the front of her car to do it. And then the Austin PD tried to charge her with road rage for chasing him down in her car with a busted axle to make him stop so she could get his information.
Hit and run, and she chases
Exactly.
him, try to charge her with road rage.
And then we caught them. They were going to go through this all the way to the bitter end. And then on the Friday before trial, on Monday, she followed the instructions I gave her to a T. That's the one thing that saved her. She did what I told her to do, and she did it right. And one of my rules is the week before your trial, you will check that court record every single day you can. But most especially the day before trial, you must check the court record to see what they've tried to slip in without giving you proper notice of. Well, that very freaking week, the Tuesday before that Friday, they had quietly submitted a dismissal of her original case, then refiled it under a new criminal complaint to give it a brand new cause number, and then reconfigured their her trial on Monday to operate under the new cause number. Now, does anybody know what doing those two things, dismissing her original case and refiling it under a new cause number, what that does to her defense?
Voids it.
By?
Because her defense is tied to the original case.
Her defense in what way is tied to the original case?
All the documents and all the evidence, everything that she's filed in is under the original case.
Correct. They tried to nullify. They tried to nullify all of her legal pleadings in the case by dismissing it and refiling it without notifying her. They did it in complete fucking secret in an ex parte communication between the city attorney and the municipal judge and did not notify her of it. That's fucking blatant due process violations on its face. And she caught them at it red-handed.
That is criminality right there.
Yep.
Due process violation.
She actually caught them at it 30 minutes before the court clerk closed for the Friday night. She immediately called me on my cell, which thankfully I was sitting at my desk and it rang and I got it and I got her call. And I said, okay, here's what we do. After she explained to me everything that she found in the court record, I said, here's what you do. You go over there to the court clerk. You have her print out every single thing you filed in this case. You immediately write the new cause number across the top, cross out the old one, initial that change, write in the new cause number, and refile it in this case right now. While you're doing that, I'm going to write up a new motion and send it to you to file. And I wrote up a new motion accusing them of judicial misconduct, bias, prejudice, and crimes against the due process rights of the accused, and told her to submit that immediately in the case. She got it printed out. I emailed it to her. She emailed it then to the clerk. The clerk printed it out. She signed it, submitted it back to the clerk. The clerk filed it in the case. We went in for her case on Monday morning, and they called out her name and called her up to the front and immediately said, here's your dismissal with prejudice order. We had caught them red fucking handed. We had them hands down and they fucking knew it. And all they could do was throw the case out, or they were in so much fucking hot water, those judges were going to be cooked up to their fucking ears. And they immediately dismissed it.
I'll tell you what, these judges now don't have any fear of anything, and they don't care.
Oh, they would if it would land them in jail. And that's exactly what that bullshit would have done. Not only would they have gotten removed from their position as a judge, they would have gotten sent to fucking jail for official oppression, abuse of official capacity, tampering with a government record, denial of the rights of a due process of an accused.
Ex parte communication.
Exactly. They would have had the fucking book thrown at them.
Could she not have continued on with that if she wanted to?
No, she could have sued them for it.
Right.
Did she judicially complain and bar complain?
She didn't do it because she was of bad health to begin with, and she could not take the stress of doing one more thing. She was happy with the win and did not feel like she could go any further than that. So nobody could act in her place. I did witness it. I helped her do
You
it.
should, yeah, you should have, at least you could have sent in the
Nope.
complaint.
No,
Nope.
I did bar grieve the judges and the city attorney over it.
Okay.
Okay, I did file bar grievances because of it, and I filed
good.
and I put in everything that we got from the court record that proved what they had done. I attached it to the bar grievance, but of course the state bar doesn't tell you what they decide. Everything they do after you submit it, they don't go public with it unless there's a public admonition.
I don't know if you've been keeping up with the news, and people are asking for the same thing now, but the Texas Education Agency has now put up on their website for people to view educator misconduct that's in current procession on their website for anybody, parents and educator, whomever. They can see who has active complaints against them. And some people are already saying, well, why the hell don't the police, the state troopers, the judges and all of that also have some type of web page where we, the public, can gain access to those that are currently under investigation or in litigation because of misconduct.
Yeah, and every public official should be listed on a website like that. There should be a publicly accessible, maintained website that provides information on every grievance against every public official, regardless of what their fucking job is.
Yeah, I agree.
That should exist in every state of the union. Every disciplinary record, every complaint, every bar grievance, everything. But again, as long as lawyers control every single branch of our government, that will never, ever happen, and we know it. This is exactly why lawyers should not be allowed to hold public office in any capacity
No, it's
whatsoever.
conflict of interest. Yeah, direct conflict of interest.
Okay, in any case, Helen, has there been any movement in your case at all?
No, not yet. I go back the 15th, so we'll find out what they plan to do, not do, what they want, don't want. I don't know.
Okay. Did you already file a judicial conduct complaint against this judge?
No, I haven't. And you know what? I need help with that.
Okay, why? It's a simple
the last conduct complaint I sent in about the asshole at the municipality, they said that I argued about how he ruled, which the last that I looked, I didn't argue that because I tried to avoid writing anything about how he ruled. I put in there the elements in which he actually screwed up, by which he violated due process and things like that. And they're saying, well, you argued the way he ruled. Bullshit. No, I didn't. I argued about the mistakes he made knowingly and willfully committing misconduct and official oppression and ex parte communication with the prosecutor. So, yeah, I argued that. And they said, oh, well, you argued about the way he ruled. Bullshit.
Well, that's why for every area of complaint you have, that's why you do a separate bar grievance.
Yeah.
They will use, when you talk about the way he did A and then the way he did B and then the way he did C, if they can find a way to deny you either A, B, or C, they can then use it to deny everything.
Yeah, and I think that's what they did. I think you're right on that. So, yeah, I think the bar grievance would have been maybe possibly a bit more, more scrutinized, but who knows? But yeah, I do need to grieve this son of a bitch. I feel like he ain't worth a shit like the rest of them.
Well, don't mention the ruling.
No,
just state that the judge in this case has demonstrated bias and partiality to the prosecution by blatantly failing to observe, to read and apply the law as it is written.
Yeah. I feel like that because the denial of my, for the discovery, for example.
Well, hold on. Before we get there, let me finish my thought on what I'm talking about here, because this is important. And then you point out specifically the evidentiary example of what you're talking about. A case was filed under this number, blah, blah, blah. The charging instrument in this case is a criminal complaint that reads thusly. And then the complaint specifically contains an element not contained in statute. The defense objected to this as a defective charging instrument. The judge ignored the law to say there was no defect, despite the fact that the element stated does not exist in law. Okay? Now, they're going to try to say that that goes to how he ruled on your objection to the charging instrument. But here's the thing. A defective complaint is ruled upon as a matter of law, not upon judicial discretion. The judge had a duty to find, in accordance with the actual statute, whether or not the complaint was valid. The judge failed to do that. Okay? That's neither an abuse of discretion nor something that has to do with a judge's ruling. It has to do with it being a matter of law that the judge ignored.
Yeah, that absolutely makes sense. Oh,
Eddie,
man.
Would that also be applicable to my case where the judge has filed discovery or signed discovery orders twice and then done nothing about it when the DA didn't provide the discovery? Would that be?
No, because the judge has the authority to change his orders.
Mm-hmm.
The problem then becomes, is it an abuse of discretion to change his order to favor one party over the other multiple times when the party being favored has ignored the court's directive multiple times?
Yep.
That becomes an abuse of discretion. That you can challenge on appeal.
Okay.
But you can also challenge it as a partiality and bias argument to get him to self-recuse.
Okay. We're moving in that direction here pretty quick. I need to arrange for motions hearing on all my unanswered motions, and I just need to prepare myself to be able to argue over those motions at it, which is where I'm working on right now.
Okay. Anybody else have anything new to talk about as far as a case or anything like that? Or any questions over what we're talking about so far? No? Well, all right. Now, at some point, Jane supposedly is going to come on here and tell us about the outcome of her case. I emailed her and asked her to come on and tell us about what happened in her case. But she hasn't signed in yet. She should be home by now, according to the email she sent me. But she hasn't logged in yet, so we'll see. Not unless she's appearing under a name listed up here that isn't actually hers. But in any case. Okay, so as everybody in class knows, we have been studying how to conduct a cross-examination. Everybody knows how to lay a trap now and how to walk the witness into that trap, right? And the way the simile we used for this was running a side of beef through the chute at the meatpacking plant. Okay, sending them from the beginning, from the trailer all the way up to the slaughterhouse. And everything in that process deals with getting the animal further and further down the chute in a way that the animal can't turn around and backtrack or take a side route to avoid the slaughter room, et cetera, or keep breaking away from the guide that gets them into that slaughter room. It's always keeping the animal moving forward and into where they need to be. So, boom. The end comes the way it's needed to come, et cetera, et cetera. So the thing here to win your case is you've got to basically do the same kind of process with a witness. You've got to walk them down the path, keep them from backtracking, catch them in a lie, keep moving them forward, or get them to testify to something in such a way that they can't turn around on it later, which is the backtracking part. Okay, so the way you get them to do that is you ask your question, then you get them to restate the question in a way that you get them to affirm that that is exactly what they mean and exactly what they said. In other words, you make them double down. Once you get them to double and or triple down on something, now it becomes impossible for them to backtrack and say that's not what they meant. That's not what they said, because it absolutely will be what they meant and what they said, and you got them to lock themselves into that through their testimony. If they try to backtrack at that point, all testimony that follows from that witness will be considered as non-credible. Okay? And that's the goal. Destroy the witness's credibility or catch them in a lie and thus destroy their credibility, okay? If you catch them in a lie, it just goes a lot faster, but you've still got to walk them down the primrose path to get them to the point where you can expose that lie. That is a process, okay? What's the case law you posted, James? Pro se complaints filed by people must be held to a less stringent standard. Yeah. The formality of the pleading must be held to a less stringent standard. Now, what do you understand what that actually means, though?
Well, what I'm using it specifically for, and I'm not arguing what you stated to me about the fact that I put my special appearance after the summary in the last pleading that I filed.
Yeah, but that's what I'm asking, if you understand what that actually means. Less stringent does not mean less process.
Okay.
Less stringent is talking about the way you word and artfully make your argument.
Okay.
But it doesn't prevent you from having to answer or put in everything that's required to be there. You just don't have to say it in the same flowery or legal language that an attorney would have to.
Okay.
But you would still have to cite everything that's required to make your case and give you a cause of action, right?
That's correct.
Right. So that is what that means. The problem with what you're talking about is what we discussed in relation to your reservation of rights of a special appearance is that is procedural, and you don't get a break on procedure.
Okay.
Okay?
Okay.
There is case law out the yin yang that says very, very plainly, the moment a special appearance argument is made, okay, if it is made after anything else relevant to the case, that becomes a general appearance. And once a general appearance has been made, special appearance can no longer be substantiated. Okay?
Roger. Got it.
That's the problem. The moment you proceed in any way procedurally or argumentatively or addresses anything factually related to the case without first making your special appearance statement, you have made a general appearance. And from that point on, special appearance is off the table. With the sole exception being, special appearance for the purpose of challenging personal jurisdiction is off the table. The sole exception being is if the court could never have acquired personal jurisdiction in the first place, i.e., the person they're attempting to bring into the case is not even somebody who lives or has ever even been in the state in which the case has been filed and has absolutely zero nexus within the state for the case to ever be held there. Okay? That's the only exception that could not negate special appearance for personal jurisdiction challenge.
Well, I've got one other possible exception for you to consider, and that is if they don't even know what the hell they're doing and they don't even know what the rules of special appearance are in the first place. If they don't...
Won't matter. If the court record shows you did this in the order that I'm talking about,
yep,
the court record is all they need to show that the special appearance went by the wayside.
Right, but they have to know that puts it by the wayside. They have to be smart enough to know that, and I don't think this judge knows by a bunch of stuff that he's already stated about not even knowing how many days that the DA has to answer on a motion that I filed before he rules on it, which he didn't do anyway. But so I don't even think this judge even knows the rules of special appearance. But in appellate,
again, it won't matter. The record will show what's there and what's not. And the higher court can always look at the record and say, right here, special appearance went out the window.
Got it. Thank you.
Yes, sir. All right, Jane's home. I just sent her the link to the class, which I don't understand why she doesn't have it since she's still on the mailing list, the email list to get the class notification schedule. So she should be in here in just a minute. All right, anybody have any questions or comments on anything we've touched on so far? Anybody new to the class that hadn't been here before? Who is Ethan Bushnell? Ethan, would you mind introducing yourself, letting us know what brought you here?
You might have to you'll probably have to unmute yourself, Ethan, if you know how to do that on the Zoom call there.
If you're actually trying to answer, if you're not even there, that's another thing, but still. No, all right. Well, that's okay then.
How are you doing?
Oh, okay. They don't have a microphone hooked up, they said. Hello, Ethan. All right, I understand. No problem.
How are you doing with your ribs, Eddie?
They hurt like hell.
Do you have any joint muscle pain as well? Just curious.
just that shoulder on that side.
Well, my aunt says there's a remedy that she's been trying from the Tractor Supply, and it's been working, and it's for horses. And she
Really?
says it
The
actually
horse can
works.
tell her when it's no longer feeling the pain?
No. It's an ointment for horses. It's a liniment.
Yeah, horse
It's
liniment.
made with, it's got spearmint and natural herbs, and she's been using it because she has a lot of joint muscle pain due to arthritis.
Well,
it's helping her.
I've got the human version of that. It's called Tiger Balm. Tiger Balm is one of the best pain ointments you can get. It's an Oriental ointment that they make, and it's extremely potent.
They sell it at HEB.
Yeah, Tiger Balm is the bomb. It's the thing. All right, Jane, make it in here yet? Still not yet. I swear, that woman is so damn slow at doing things. She walks forward in reverse. How's that old saying go? One step forward and 2 steps back. But yeah, I've got a big bruise on the right top side of my chest right now, right up against my armpit, and I have no idea why there's a bruise there, because that's not what hit the tree. But the bruise is about 10 inches from where the actual impact took place. Is
the whole area possibly, when you fell, did you fall forward and try to catch yourself?
I couldn't see. It was 4 o'clock in the morning, pitch freaking black, and I fell into a tree growing out in the front yard. It's one of those decorative trees that's got like 5 trunks coming straight up out of the ground all together, that basically they're not actually forks, but they're close enough together they act like a fork in a tree. And I fell face forward. My arm went right through them. My hand never touched anything. And then I fell full weight and impact directly into one of those branches of that, or trunks of that tree coming up out of the ground, and got wedged right between the two.
On that side where you're bruised, right?
Exactly. On the same side.
So the whole area was...
Yeah, but the area where the bruise is didn't actually touch anything. It was below that, about 10 inches below that, where my body actually went, slammed in between those 2 tree trunks. And it took me almost a minute to catch my breath enough to pull up and get out of there, because my leg wouldn't work, where that piece of concrete bashed on my kneecap and took all the feeling right out of my leg. I couldn't stand up on that leg. I couldn't push myself up with that arm because of my ribs, and extricating myself from that tree fork was not a lot of fun. All right, Jane's in. Jane, welcome to class. Would you please explain to everybody what your case was? Don't get too long-winded about it or too much detail. Just explain simply what it was, and then give us an explanation of what happened and what the outcome was.
Well, I just found out the outcome just right after you requested that I join the class. I'll just tell you the ending first.
I thought you told me in an email the other day they wound up dismissing it.
Yeah, I did, but the outcome ultimately is not. I'm not concerned about what the municipal court did. Remember, that's something you always said. It's that I got it in a petition for discretionary review in the Texas Court of Criminal Appeals.
For the constitutionality, though, right?
It was the denial of the habeas. Anyway, they refused to grant review on the case. I just got that right before I signed on. I just noticed it was...
Well, but if they dismiss the case in the municipal court, then that becomes irrelevant, right?
Well, no, it's not relevant, but irrelevant because there's still underlying controversy. I mean, it hasn't been resolved. They dismissed the case in the 5th District Court of Appeals because the municipal court dismissed the prosecution. And
right.
Yes, but that doesn't automatically moot the case, because that's what they're trying to say. It was moot. Well, it's not. That's only if it's only moot if the issue's been resolved. Like, say somebody was...
No, that's not true.
That is true.
No, because... Okay, when did they dismiss it?
They waited until it got into the 5th District after they saw...
Right. But how did it get you filed an appeal to the 5th District Court, right?
Well, I did after it was denied in the county court for the appeal for the habeas.
Right.
Then I appealed that to the 5th District, and they denied it, or I guess it's denied is the right word.
Then you've lost me on your process here.
Okay.
Okay, here's the thing. This was an animal control ticket issued to Jane by an animal control officer that didn't witness a fucking thing.
And
they were acted on behalf of an abusive neighbor that actually complains about Jane all the time, which, in all honesty, if we're being truthful, Jane probably works her ass off to get people riled up at her to begin with, but that's another story. In any case, I like Jane, don't get me wrong. I give her a hard time, but I actually like Jane because at least she's willing to fight.
Yeah.
But did you go to trial in the municipal court on this case?
No, that's the reason why I filed the habeas, because I didn't want to go to trial.
Okay,
Because
I understand.
I went to 2 pre-trials.
Okay, but again, she never got to actual trial in the municipal court. She filed all these motions. She filed a habeas pleading and all that with the 5th Circuit, I guess she said.
It was, okay, what happened in the municipal level, it was months and months of doing back and forth because the city kept changing the complaint. And
they got like 6 different ones before it was all over, right?
Well, it was like 4, but anyway, they and because I went to pre-trial 2 times and I saw how the judge was going to do, you could just tell that he was going to go with whatever the city said. He doesn't care about justice or anything like that. They don't care. They just go with whatever the city attorney tells them that they're going to do. So I saw how it was going to go, and I decided I didn't want to do that route. I didn't want to go to trial because it's a waste of time. And because I knew that they were going to prosecute me and convict me, and it would cost money to do the appeal. That's the reason why. And because of the case was actually unconstitutional and unlawful, but since they didn't have an actual charge that against what it was that I was doing, they just made it up. And so the ordinance itself is unconstitutional. And
that was the challenge we made to it. Yes. Yeah.
And not only that, but the prosecution was actually unauthorized and unlawful. So and that is ultra vires. So anyway, so I appealed. So I filed a habeas in the county criminal court 1. She denied it right off the bat. And while waiting on that to get the same night I came home from filing that, I had a bunch of denials in my email from Irving Court because I had filed like 8 objections in the court when I was in the pretrial, and they denied every one of them based on a standing order that they backdated to before my trial, even though it wasn't there it wasn't presented to me before the trial. But anyway, so I filed a supplemental to the habeas and to let the court know about what the court was trying to do, about what Irving was trying to do. But that didn't matter. It didn't matter because, matter of fact, I don't think there's any justice in Texas anymore. So I wrote a really good appeal brief, and it was rock solid. Now the habeas was questionable because it got maybe a little bit into merits where it shouldn't have, because the whole challenge was to the constitutionality, and it's a not as applied. As applied would be like applied to my situation. But I didn't want to do a challenge to my situation. I wanted it to be a broad, what's the other word for it? Facial. I wanted it to be a facial challenge. And so they could prevent them from doing this to other people. And, so it's not like I was trying to look out. I'm sorry, I'm getting upset.
Well, don't get upset.
Because I just not got this refusal, and I didn't really expect this. But looking back at the PDR, and even a couple weeks ago when I read it again, I thought, man, that's too nice. I mean, it's too sugar-coated or whatever. It's not convincing enough. I should have been harder on it, but it is what it is. And so anyway, going back to where I was, it's been a long time fighting this case, and it's bullshit,
Agreed. And that was the whole premise of why we fought it in the first place, right?
Yeah, I know. And so it's like It's like the Texas Court of Criminal Appeals is just blatantly turning their head and allowing these submissive courts to do whatever they want to do, you know, without any kind of consequences. And that's the whole reason why I did the PDR, was so that they would force the District Court of Appeals to actually review the appeal brief on the merits of the brief. And so the 5th District did not even read the appeal brief, because after that was filed, when the city responded with their dismissal of the prosecution, and they cited 2 cases that are absolutely irrelevant. I mean, have nothing to do with like the type of case mine was.
They don't necessarily have to do with the type of case. They may.
I don't mean it that way. I mean procedurally, or they dismissed it based on restraint that was relieved. Like, say somebody got out of jail, or someone their some kind of relief was granted in a way that they were not restrained anymore, and so that was not my
right. And that would be synonymous with the municipal court dismissing your case.
It's not, though, because if you read in the Supreme Court, it says that a case is not moot just because of dismissal of a prosecution whenever there's still underlying controversy, which there is and was a challenge to the constitutionality of the ordinance.
Stop. Okay. Here's where you've got that mixed up. Okay. The case or controversy here in this case for you was the criminal allegation against you by the city. It was not your constitutional challenge to the ordinance. Stop.
Right.
The controversy relates specifically to the use of that ordinance to criminally charge individuals for an offense that can't possibly occur under the ordinance. Okay? And that the ordinance itself is vague and overbroad.
That's exactly
the constitutionality part of it.
Yeah.
But it all hinges on the criminal allegation and the prosecution of you, not your countermand. Stop, Jane.
Okay.
The constitutional challenge is civil. The case against you was being treated as criminal. Exactly. Those two things cannot cohabitate in the same case, Jane.
Here's the thing. Here's what makes it different. It's because of the fact that I'm challenging it facially and not as applied.
Again, that requires you to file a civil suit to do that.
And that's still going to happen. That's still going to happen.
Okay, but my point here is, if you'll listen to me long enough and drop your prerogatives of ignoring what I say and listen to me for a second, you cannot mix a civil counterclaim with a criminal prosecution in the same case. Cannot do that.
I don't. Okay? Did you see it? I don't think
listen to what I'm telling you, please.
Oh.
The reason that the higher court dismissed your motion the way they did,
they refused it,
citing that there was relief granted, that was the dropping of the criminal prosecution against you. Okay, that drops the criminal defense of the statute being unconstitutional, or the ordinance being unconstitutional on its face, okay? Because that was your legal defense against the criminal allegation. That was not a civil suit for you to get the ordinance thrown out and make it unenforceable. Do you understand the difference between those two things?
I understand that I cannot file.
Wait, stop. That's a yes or no question.
I don't agree with that, because the reason why
you don't have to agree with it. Do you understand it?
I understand what you're saying.
Okay. Now, if you want there to be a controversy that remains relational to the constitutionality of the ordinance, that requires you to file suit. Okay? Which you could do as part of your malicious prosecution suit, which you do have. Okay? Because the case was resolved in your favor the moment they dismissed it. What?
That's not resolved in my favor, though.
Yes, it is, Jane. When they dismiss without finding you guilty or finding you, that's a fucking win. Which part of that are you not getting?
That I don't agree with because they still spent all those months.
Okay, once again, you are sitting here trying to say what you don't agree with and substitute it for the way the law works. Stop doing that. I don't care if you disagree with it or not. It's the way the frickin' law works. Well, that's the part you need to get through your head.
Okay, but
they dismissed your criminal prosecution.
Okay.
Did they not?
Yes, they did.
Okay. That works in your favor. The outcome is in your favor. The case was dismissed. Period. End of discussion on that point. You won. They lost. Okay? Now, you have a counterclaim in the form of a malicious prosecution suit, which you can also use to constitutionally challenge the facial validity of the ordinance. Do you understand that part?
Then what is...
Don't then me answer my question. Do you understand that part?
I understand that. That's not how you do it, though. How come we were challenging initially in the criminal case the constitutionality of the ordinance?
Because that makes the ordinance unenforceable for the criminal charge, Jane.
Exactly.
That was your legal defense against the crime, not your civil complaint against the ordinance.
I'm still going to do that, but I don't...
But you're not listening and separating the two things into their individual categories, Jane, and that's the problem. You're keeping them joined at the hip like a pair of fucking Siamese twins.
Okay, but what if I had case law to back up what I'm saying?
You don't.
Okay.
I guarantee you do not have case law that says a civil challenge to the constitutionality of an ordinance allows a criminal prosecution to continue for the purpose of challenging the ordinance if the prosecution itself is dropped by the prosecuting party.
All right, let me see here. I think I do.
If you do, I guarantee you're misreading it.
Okay, I had multiple cases, not just one. Let me find it. Let's see right quick. That's right. Okay, Ex parte Flores, Ex parte...
Ex parte Flores is a case dealing with what? With an outcome of what?
I have to see if I can find the parenthetical because I've been off of this for a minute. Matter of fact, I'm on the board of directors at the HOA now.
give me the citation for the Ex parte Flores case.
Okay, that one.
Or a link to it. Put it in the chat.
Okay, all right. Let me see if I can. I don't know if this is the one I actually filed because I thought I put parentheticals in the index. And I'm not seeing those. I'm hoping.
I just want to see the case, Jane. I need a full citation.
Okay, I'm not sure it was because I've got 1, 2, 3, 4, 5, 6, 7, 8, 9 cases, and trying to see which one is more. I don't know if it's Flores, but Ex parte Landry. Okay, I'll have to put it in the chat. Hang on, hang on. There's several of them, and these are all criminal. And then there's a couple of civil ones I have too that make the same point is what I'm trying to tell you. Let's see here. I'm getting ready to put them in there. I have to transfer it over to the other computer. Copy. And then I got a couple more to send over there in a second. Let me see here, chat. Okay, the very first case is missing the E. That's on the ex parte. But let's see what the other ones are. So Landry and Perry and probably Lowe would be better than the Flores, possibly. But you look at any of them.
Okay, the offense in Ex parte Flores was the unlawful carrying of a handgun. Let's see, in a vehicle as a member of a criminal street gang. Appellate filed pretrial applications for a writ of habeas corpus challenged the constitutionality of the statute. After a hearing, the trial court issued an order denying the applications. Appellate challenges the court's denial on 3 grounds. In his first issue, appellate argues. I'm going to get this on a bigger screen here where I can see it. I'm going to share this out where everybody can see it as we go so we can see what we're dealing with, okay?
And I'm putting 3 more in there, and that's all.
Everybody can see the screen?
Yes.
Yeah.
In his first issue, appellate argues the statute violates the First Amendment to the United States Constitution because it is a content-based regulation of expression that fails to satisfy strict scrutiny and because it restricts freedom of association. We conclude the statute is not subject to strict scrutiny because it is justified without reference to the content of any expression and does not infringe on any right of intimate or expressive association. In his second issue, appellate argues the statute is unconstitutional because the terms criminal, street gang, and member are overbroad. In his third issue, appellate argues the statute is unconstitutionally vague and provides law enforcement with unfettered discretion to arrest individuals. We conclude that appellate's arguments rely on an incorrect construction of the statute, and the statute is neither overbroad nor vague when correctly construed. We therefore affirm the trial court's denial of the writ applications. How do you see this supports your position in relation to this ordinance? Where in let me look
to see how we used it in my PDR.
Other than you're using the same words, unconstitutional, vague, and overbroad.
No, there would have been a reason.
I understand you think there's a reason. Mine is trying to figure out what the fuck you would think that is.
It would be a specific holding. It might not have been a primary holding. Let me see here. Let me see how I use it. I'm going to look right quick.
Okay.
All right, on 16, it's on page 16. I'm looking right now. 16. We said, hell, I don't even see.
I can tell you exactly why. You're using it because of this paragraph right here. I bet dollars to donuts that's why you're using it. A claim that a statute is unconstitutional on its face may be raised by pretrial writ of habeas corpus because the invalidity of the statute would render the charging instrument void.
I might be looking at the wrong one.
Although pretrial habeas can be used to bring a facial challenge to the constitutionality of the statute, it may not be used to advance an as-applied challenge.
Right, and I wasn't doing as-applied. I was doing facial.
Again, so what?
Okay, the next one. Look at the next one.
The state argues that we may not address appellate's three issues because they are in fact as applied constitutional challenges and thus not cognizable in a pretrial application for writ of habeas corpus.
His wasn't. That's right. As applied is not, but facial is.
Can I finish this?
Okay.
We disagree. In his three issues, appellate argues that the statute is facially invalid, because it is a content-based restriction on speech and is both overbroad and vague. If we resolve these arguments in appellate's favor, the trial court would be deprived of the power to proceed and appellate would be released. See ex parte low. Concluding statute at issue. Sorry. Concluding, you said that's one of the other cases?
Yeah, ex parte low is one of the other cases, but don't look at Huarte or Landry because that's what the city.
I'm not going that far. Let me finish what I'm reading.
They use those two cases, and those
ex parte low. Concluding statute at issue was overbroad, content-based restriction on speech, and remanding case for trial court to dismiss indictment. Well, again, I don't see where speech would have anything to do with a charge of unlawful carrying of a weapon. There would have to have been some other thing they used that dealt with speech or signage or language that resulted in the arrest that exposed his carrying of the weapon that would have made his prosecution unconstitutional based upon the initial thing and thus resulting in a fruit of the poisonous tree argument. Okay? That would be one way I could see him doing that. But the basis of this case has to do with the unlawful carrying of a weapon. I failed to see, and I don't see anywhere in the unlawful carrying of a weapon statute in Texas where speech has a damn thing to do with the charge. So he is either making an argument that has nothing to do with the charge against him, or there had to be some other preliminary thing that led up to the discovery of the weapon he wasn't supposed to be carrying in the manner he was carrying it, that he's claiming was unconstitutional and thus resulted in a fruit of the poison tree search. You get what I'm saying? That's the only thing I can see that would get us to this point. Now, if there's something else, I'd have to read the rest of the case to find it. But every case you're citing has to do with content-based speech. And none of that has anything to do with your case and your challenge. You're charging that the ordinance is vague, ambiguous, and overbroad because of the way it is written. A facial challenge to its construction, which has nothing to do with speech. So again, neither the issue in the case applies to your case. The defense they're raising on speech-based content as a constitutional violation is in no way related to your case. So tell me why you think these cases support you again, Jane.
Oh my God. I don't think there's no way I filed this. I don't think this is what I intended to file. Wait a minute. There's something messed up here.
Well, that part I can't help you with. If
Okay,
we go to ex parte low, appellant was charged with third-degree felony of communicating in a sexually explicit manner with a person whom he believed to be a minor with an intent to arouse or gratify his sexual desire. He filed a pretrial application for a writ of habeas corpus alleging that this specific subsection of the felony offense of online solicitation of a minor is facially unconstitutional for 3 distinct reasons. It is overbroad and criminalizes a wide range of speech protected by the First Amendment. It is vague because the term sexually explicit communications that relate to sexual conduct chills the exercise of free speech by causing citizens to steer wide of the uncertain boundaries between permitted and prohibited speech. Not when they're directed at an underage individual, you fucking morons. And this is his defense attorneys making this argument. It violates the Dormant Commerce Clause. Okay. This was a definitely fly by the seat of your pants attempt to get this guy off.
Okay.
That, or is it defense attorneys were intentionally trying to throw him under the bus?
Hang on. I'm gonna send something else in the chat.
Okay.
All right. Look in the chat right now. I'm gonna paste something else. This is how we use. Oh, that's not giving you the right information, I don't think. Wait, hang on. That's not the right thing. I just double pasted something.
Well, so far that would cover about everything you've put in there.
Okay, I didn't mean to double paste that. What I just did. I'm trying to show you how we used it, or how I used it, or whatever. If I can get the hush trouble. I gotta get out of this full screen. Okay, let me see here. Oh, I see what happened. Okay.
Should I ask what happened?
No, I'm hang on, sorry. Copy image. Okay, now let me go paste. If I can find you again. Where are you? Oh, here it is. Hope this put the right thing in there. Okay, look, pull that up. That's how I used 3 of the cases in here. Are you looking at that, or are you looking at something else?
I'm trying to look at what you just pasted in there. It's a screenshot.
Yeah, it's a screenshot.
Okay, so
I mean, I was in the PDR.
You're wanting to use ex parte Perry? Is that what you're pointing me to?
Yeah, that's one of them, and the other ones that are in there.
Well, one of them is the ex parte low you just gave me, which absolutely has nothing to do with your case.
But what did I say on the ex parte low? I would have put a parenthetical in the citation. What did it say?
According to this, facial constitutional challenges are cognizable on pretrial habeas because they implicate the state's authority to prosecute. All you're citing these cases for is the authority to prosecute, okay? That's the only, because you're challenging the validity of the charge in the charging instrument, okay? All of these have to do with the authority to prosecute. That's the only 2 citations you made. Pretrial habeas is available to resolve pure questions of law that, if sustained, would bar the prosecution altogether. That's your Perry case.
That's right.
Ex parte low. Facial constitutional challenges are cognizable on pretrial habeas because they implicate the state's authority to prosecute.
That's right.
Okay. Still has nothing to do with the fact that when the state itself ceases to prosecute, your habeas is dead in the fucking water.
I haven't gotten there yet. Hang on. Give me a second.
What do you mean you haven't gotten there yet? What the hell does that even mean?
I mean, I'm not gotten to the rest of the, because you have to cover.
It doesn't matter.
Huh?
I'm trying to get you to understand that doesn't matter.
Okay, here's my proof that it does. Hang on, I got it right here. I just couldn't find it fast enough.
Okay.
There is a case, and I'm sending it to you right now. I just now found it. It's in my PDR.
I'm waiting. I'm waiting. Just give it to me.
Trouble. I'm gonna do nothing but shush. Spoiled brat. Let's see here. All right, it's right here. Okay, pull up that screenshot.
Okay, let me see here.
What?
The Court of Appeals erred by treating post-jurisdiction dismissal as rendering the appeal moot. This is what you argued. This case presents a question this court has not resolved. The effect of dismissing a prosecution after appellate jurisdiction has attached on a pending pretrial habeas appeal. Do you not understand how appeals work, Jane?
Yeah, I do understand.
Okay. Then you understand that if the case for which the purpose the appeal itself was made, gets dismissed for any reason, the court in which the appeal is filed is now deprived of jurisdiction to proceed because the issue has been resolved.
I understand that, except unless there's a facial challenge. And look up the next one, the one I just sent you, and one I just now sent you again. I sent you another one.
Okay, do you see what this says down here? And you cited it.
Okay, is it where is it?
Appellate jurisdiction, once invoked, is determined by law and cannot be defeated by subsequent actions of the parties. That's what you cited.
I don't see it on the screen. You got something else up there. There's something else.
You don't need to see it on the screen. You gave me the damn screenshot. You have the document. That's what you put in your motion, right?
Okay, read the next one.
I can't read the next one because there isn't a next one.
Yeah, it's in the chat.
Okay, again. Courts recognize that issues likely to recur in ongoing enforcement but susceptible to avoidance through dismissal may warrant judicial resolution. Well, there's that word may that you put in there. Okay, so let's see what the State v. Lodge says. Recognizing that issues capable of repetition yet evading review may remain justiciable notwithstanding mootness concerns.
That's right.
Okay, so let's look up State v. Lodge and see what State v. Lodge says relative to that statement. Okay, State v. Lodge.
Then you look at the Matthews versus Coates also.
Let's get through this one case at a time, Jane. Southwest 3rd, 9/10, 2020. Okay. State v. Lodge, 608 Southwest 3rd, 9/10, Texas Criminal Appeals. All right, Lexis does not have any such case. Or I'm sorry, Google Scholar does not have any such case.
Not everything's on Google Scholar.
I know that, Jane. That's why I'm not settling just for Google Scholar.
Okay, good. Probably got it off of a fast case.
Guess what?
What?
Google has never even seen this case. And if Google hasn't seen it, I guarantee you it doesn't exist anywhere.
It exists. Which one was State versus Lodge? Yeah, it exists.
Well, not with the citation you've got here.
I hope I didn't put the wrong one in, but let me look. Let me look right quick. I'll have the case.
There is a State v. Lodge that's 461 Pacific 3rd, 8/19 from 2020. That's on Google Scholar.
This one's a Texas court. Let me find it.
Yeah, I see it's a Texas Criminal Appeals case, and it should be on the Texas Criminal Appeals site if it exists. Okay. And it should have come up in this search if it exists.
All right, hang on a second. I'm going to find the case. I'll have it in my computer right here. State v. Lodge. There are so many cases I could have used. Where is State v. Lodge? God, no, the cat is fucking getting on my nerves. Go. Yeah. Get out of here. Go.
Okay. Well, the AI found it, but it doesn't say where.
Good, because I can't find it right now. Got too much pester in my ear. State v. Lodge. Oh, I know it. Where is it? I don't have it on my computer. What the hell?
Okay, the only place that seems to have that case is Justia.
Okay, that's probably where I got it then.
Problem is, Justia's for pay. You can't get it for free off of Justia.
Okay, hang on. Let me see if I find another way. Okay, do you have this citation? 608 Southwest 2D 910 Texas 1980?
No, I've got Southwest 3D is what you have in your document.
Damn it. Well, I had the wrong citation in there. Oh, yeah, this one was about a mental health thing. A mental health case. Let's see here.
Which one was? The 2D or the 3D?
The 2D. And then this one, and this is the citation that we use. A case is not necessarily moot if a challenge action is so short-lived that it will likely end before appellate review can be completed. and there is a reasonable expectation that the same complaining party could be subjected to the same action again. That's
Right.
that's what we cited.
But here's the issue. If that word "if" right there is going to be the thing that deals with your mootness concern.
Yes.
Okay.
Mm-hmm.
Number one, how old is the case we're talking about? Your case.
Mine is 2025, I guess, March.
March of 2025.
Yeah.
And I assume, after all we talked about, you filed a motion for speedy trial, right?
No, I did not.
You did not.
No, not on that one. I did on the other one, speedy trial, on the speeding ticket before.
Okay. But the state has failed to prosecute for the entire year and what? How many months?
It was not, they had 2 years they could have done it.
I know how long they have.
You mean to find me convicted, or because I was being
to
prosecuted?
actually prosecute the case. How long? When did they file it, and when did they dismiss it?
Oh, they filed it initially right off the bat, so it was like within a couple
A
weeks.
date, Jane. A date.
It would have been in April 2025.
April of 2025, which would have put it a year. 2 months ago?
Yeah,
Okay, so 14 months, right?
yeah,
14 months for a Class C with no prosecution, right?
yeah.
Okay. Then they dismissed it. Did they dismiss it with prejudice?
No.
You're sure?
Well, I have the dismissal.
Does it say with or without prejudice?
Let me see. I can't remember, but I think it was something that somebody was raising hell with me about, that I needed to get that, which I knew it was. It just says dismiss. I don't think it says with or without. I don't think it's
Well, if it doesn't say with, then it's always without by default.
okay.
All right. But regardless, that means they've only got how many months to refile and try again?
I don't know.
8.
Okay.
Okay. If they weren't able to get you into court in 14 months, why would they keep wasting money trying to get you there again in 8?
I don't know. They wouldn't, I guess.
Okay. So I'm willing to bet that that's something that the appeals court took into consideration, and then they got notified at some point that the underlying case that you're appealing was dismissed. Now, a dismissal doesn't simply render the point moot. Okay, you're trying to make a point, and this other thing renders it moot. The dismissal alone may or may not jeopardize that, depending upon what the dismissal is and how it works, and what the offense itself may be in some cases, the level of it especially. Okay, felony versus misdemeanor. You get what I'm saying?
Mm-hmm.
The appeals court can take all that into consideration. They can look at the time frame involved. Are we past the statute of limitations for them to refile this case? No. Well, how long do they actually have? 8 more months. Well, how long has this case been going on? Obviously, the answer would be 14 months if they got 2 years to do it. The thing is, the appellate court can say, okay, odds are this is not going to get refiled. If there's no chance it's going to get refiled, especially if they'd outright said it was with prejudice, the appeals court is now deprived of jurisdiction to answer your question, because there is no controversy to keep jurisdiction in the appeals court, even considering your mootness argument, because a dismissal doesn't have simply a moot point to it. Can it? Yes. But in your case, they could have said this is beyond moot. Okay? They could have done that. I'm not saying they did or they didn't. I'm just saying they very well could have. But like I said, you cannot mix the civil side with the criminal side in the same case.
But here's the thing. When there's pure questions of law from the get-go.
Can I finish my thought before you start making another argument?
Finish your point.
No. Okay? My point being that now that they have dismissed it, and that renders the verdict in your favor because they dismissed it. And you can make the argument that they can't refile it now because it would constitute double jeopardy, which would also make it something they can't refile, which the trial court or the appellate court could have also taken into consideration. Has jeopardy attached? If the answer is yes, and they dismissed it, that case is fucking dead forever. It cannot be refiled. Okay? So, the criminal side is now resolved. Your challenge on a habeas for a criminal case is now resolved. Point dead. Okay? Therefore, the appeals court no longer has jurisdiction to rule on it. If they could refile, now you've got a mootness argument to consider. But if they can't refile, mootness is no longer the issue. Lack of jurisdiction as a matter of law now becomes the issue. And even the cases you cited, it says law matters more than mootness. You get me? Now that the criminal side is gone, that leaves you the civil malicious prosecution case to pursue to re-raise the constitutional challenge that would give you a facial argument against the ordinance to bring up in your malicious prosecution suit. You understand?
Mm-hmm.
And that is what I was saying, that you will never, ever find a case that says you can raise both of those issues together. A criminal allegation defense in the form of a counter civil claim. Can't do it.
I wasn't trying to do that.
Yes, you are.
Okay, read this
The
next.
constitutional challenge to a statute is civil. No ifs, ands, or buts.
Well, then why do we challenge it in the trial court?
Because it can negate the criminal prosecution if you win the argument that it's unconstitutional. It's your defense. It is not your civil claim. You do understand those are two different things, right?
Yeah, I understand they're two different.
Okay, that's why. You raised it in this case as a defense against prosecution, not as a constitutional challenge in and of itself. You raised that challenge as a criminal defense. Those are two separate things.
Okay. Did you read? Can you read the last one in the chat?
Are you going to give me a headache?
The last two cases in the chat. That's the last two.
Are you going to give me a headache?
I don't know. That's all. You control that. I don't.
State versus Rue. Appellate jurisdiction, once invoked, is fixed by law. I keep telling you exactly what that means. By law. If the court is deprived of jurisdiction by law, the rest of it is irrelevant.
Read the rest of it.
The second case, Matthews v. Kuntz, recognizing that a defendant's voluntary cessation of challenge conduct does not necessarily moot a case where the conduct could reoccur. The defendant's cessation, that would be you.
No, the cessation is the trial court dismissing the case.
No, this right, Jane, are you fucking reading the same thing you put in the chat for me to look at? It says a defendant's voluntary cessation. You were the defendant.
They are the defendant. They are the defendant.
No, they're not.
Yes, they are.
No,
that's
they're
the
not.
way I wrote it. They are the defendant in this. I know what you're saying. It's not a case, but but this case ruled on saying that a defendant, meaning that this is a civil case. It's a civil case.
Stop. Even if it's a civil case, let's look at what this says in its totality. The defendant ceases to engage in the conduct alleged in the suit or in the criminal allegation. That the defendant's cessation of that conduct does not necessarily moot a case, either civil or criminal, where the defendant could engage in the conduct again.
Exactly. That is my challenge against them.
That does not help you in any way, shape, or form.
The city is...
It does not help you in any way, shape, or form.
Appellate jurisdiction, once involved, is fixed by law and cannot be defeated by subsequent actions of the parties.
Right.
Yeah.
And then you cite a case that says that you, the defendant's voluntary cessation of challenge conduct does not necessarily moot a case where the conduct could reoccur.
And I'm talking about the city's conduct.
Stop. Let me finish what I'm saying. In this case, you are still alleging two different things. Their conduct is the criminal prosecution.
Yes.
You are challenging the constitutionality of the ordinance used to perform the prosecution. Your challenge to their ordinance is not the same thing as their cessation of the prosecution, even if they are considered the defendant, which in the language of this suit or this case, I don't see that being the case. Okay, I don't see that at all.
See, you're only reading this. I really need. There's only my PDR.
I would bet again, dollars to donuts, that if I went and read the whole case, it would still lay out the way that I'm reading what you placed here.
Well, I'm saying
I'm willing to bet that's the context in which it exists.
My PDR is only like 10 pages, excluding
But in any case, what I'm trying to get you to understand overall is this. You won, okay?
No.
You won. They dismissed the criminal prosecution. You won.
I don't see it like that. But.
Well, I don't care how you see it. You need to understand that's the way the fucking law works.
Okay.
You keep trying to confuse what you want with how the law works.
Okay, let me just read this short, just like few pages out of here. Because you're only reading like the citations and not my argument part of it.
I can only read what you gave me, and it's a fucking screenshot. I don't have the document.
I know. I don't have, well, it's 120 pages, but I'm talking about just the PDR part of it. It's only a few pages. It's only, let's see.
I was right. You're going to give me a migraine.
No. Okay, I'll send you like a page by page, unless you want me to read it.
Just read it, Jane.
Okay, the statement of the procedure.
I want to read the case, not what you wrote about the case. I want to read the case to see if you're citing the case properly in the context in which the citation you're using actually applies. I have to read the case.
What case are you talking about? The Kuntz?
Whichever ones you're trying to use to support the argument you're trying to make.
I'm saying that you're not hearing my argument. You're only looking at the citation.
Again, it doesn't matter what the argument is if it isn't consistent with the way you're citing the case in support of it.
Okay, let me just read this.
So I kind of need them both. This is the reason why I tried to get you guys, when you write pleadings, to always hyperlink your cases. Always. That way, if you send me your pleading to review, I can look at the case that you're citing as your authority and read the damn thing without having to go looking for it.
And those get flattened whenever you file it through the e-file.
That's why you have your original electronic copy that you can send to me through email that doesn't flatten a damn thing. I don't want a scanned copy from you when you have the original fucking electronic document you created.
In this case, I did not create a hyperlinked one.
I know that. I can see that from what you've got in it.
Yeah, but so the questions presented for review, I only had 3. And the question 1 was, does mootness doctrine permit a dismissal of a pretrial habeas appeal presenting facial challenges to the legal validity of a prosecution when the state dismisses the prosecution?
And you didn't address how the mootness occurred, okay?
I'm not, but because you haven't seen the...
Stop. Listen to what I'm trying to tell you here. Nothing in what you just read addresses how the mootness itself came into being.
Okay.
You understand that, right? And you understand there are different ways that mootness can be invoked.
Yeah.
But the one thing that renders mootness not actually mootness, but a matter of law, is when the court hearing the motion is deprived of jurisdiction in the case. It doesn't matter. They can't rule on a motion over which they have no jurisdiction, Jane. None. They can't do anything except dismiss the appeal or the action or whatever it may be if they lacked jurisdiction to proceed. You understand that, right?
Okay, let me tell you this to counter argue that. So then that prevents anyone to make a challenge to the appeals court.
No, it does not.
No, I mean, not through a direct appeal, through a habeas. It does not.
No, it does not.
It allows the lower courts to get away with doing whatever the hell they want to do. And
no, it does not.
Damn sure does. Because if it gets before the appeals court,
stop talking through your feelings and
That's
listen to what I'm trying to tell you about how the law works, Jane.
I understand.
No, you don't, obviously, because you keep trying to substitute the law for how you fucking feel and the outcome you want to be.
No. So then how?
Yes.
So case law, would you agree that case law is what decides what happens with in the future, like that take precedence over, and then how the courts decide? They use
not necessarily. It depends on what case law you're citing and whether or not that case law is controlling over the court, or it's simply put in as a suggestion or an advisory type of supplemental. Okay, when you put in the third circuit or the third district, you're no longer operating in the courts that have jurisdiction over this part of Texas where you're operating. Your case exists.
Yeah, I'm not trying to do that. But I didn't get to finish my question one. My question one is, does the mootness doctrine permit dismissal of a pretrial habeas appeal presenting facial challenges to the legal validity of a prosecution when the state dismisses the prosecution after appellate jurisdiction has attached, leaving unresolved questions concerning the legal sufficiency required to invoke criminal jurisdiction? That's question one. Question two. Wait, let me ask something about the response you got. Does the response you got address each of these issues you raised? That's not a response. That's my questions for review. That's one.
God damn.
I don't understand what you mean.
You got on here crying that you got a response from the court denying your appeal, right?
I got a postcard that says it was refused.
Okay, so what you got does not answer the issues you addressed, right?
No, and I didn't expect it to.
Well, then why in the hell are you telling me what they are? If you didn't think they were going to answer you based upon the issues you're trying to raise, what did you think they were going to address, Jane?
They were not supposed to address the issues. They were supposed to remand it back to the 5th District for them to address it. It's not the Court of Appeal. It's only for them to see on the face what it was that I'm presenting.
No,
and
Jane.
I didn't get into the arguments that I had made in the appeal brief.
Oh, Jesus.
Because if I had done that, I mean, if they did read it, I know what I'm doing here. I'm telling you, I know what I'm doing.
You do, huh?
So question two, these are like a window. This is not my actual challenges, what I did in the PDR. The appeal brief holds all the merits that I'm trying to challenge, and that I was trying to get the Texas Court of Criminal Appeals to.
Jane, what are you reading to me from then?
Okay, this is my questions presented for review. This is
in what?
In my PDR.
The PDR you just said that isn't the one you filed, or the one you did file for your appeal?
It's the one that I filed. I was looking further into the document because it's 128 pages. I had to include other filings in there.
Okay, so, stop. The document you're reading from is the one you filed for your petition for habeas relief. Yes or no?
No, it's no. Petition for discretionary review. Habeas relief is two courts before that.
Discretionary review by who?
By the Texas. It's for them to grant review so they can.
Don't give me a them. What fucking court?
The Texas Court of Criminal. They're the only ones that accept a PDR. Texas Court of Criminal Appeals. You can't file a PDR anywhere else in Texas. And they are the ones that decide that the appeals court made a mistake by denying my habeas appeal.
Okay, because I know what court can take them, that's why I need to know what court you're saying you filed it in.
Yeah, Texas Court of Criminal Appeals.
Well, that's what I asked you, and that's the only answer I needed.
Okay.
So you filed it with them, and they sent you a postcard in response?
They just said refuse. They're refusing to review the case. They don't want to review it.
Okay. And is there any possibility that they got the information that case no longer exists?
Yes, it's an absolute 100% possibility. But that's not my. But here's my my questions for review. Here's the three. That's the reason why it makes that not relevant. And I already told you number one. Number two.
Okay, you understand that you yourself just said a petition for habeas was two courts before, and now you're doing a petition for discretionary review, which itself is not a habeas pleading. You know that, right?
No,
Stop and answer my question.
Yes, I'm trying to tell you, God damn it. Listen, the petition discretionary review, that court looks at what that they're concerned about, what the lower courts, like the Fifth District. I'm trying to get them to review the actions of the Fifth District Court of Appeals when they denied my habeas appeal based on that dismissal of the prosecution. Now, don't go into that stuff with the mootness thing right now. So my questions for review are these three. The second question was, does a pretrial habeas corpus provide the procedural mechanism for resolving legal defects that prevent a prosecution from invoking criminal jurisdiction, including challenges to the existence of an offense and the validity of the charging instrument? That's question number 2. And that is what I'm letting the Texas Court of Criminal Appeals see, or the CCA. Question number 3 is, do criminal ordinances defining prohibited conduct using undefined standards such as danger to public health and safety present reoccurring questions concerning the legal requirements governing the creation of criminal offenses and the invocation of criminal jurisdiction? Those were my 3 questions that I'm asking the CCA to review. And then
okay. Can I ask another question? Have you looked at the circumstances under which a PDR can be filed?
Yes, I have. Absolutely.
And what are they? And where did you find them?
And I don't know them off the top of my head. Right now, I've been out of this thing, the whole mode, for about 2 months now. So I've slept since then. But I've gone by Hammond's. I'll tell you exactly whose PDRs, as far as how to write them and what's required and everything that I use to do this. I'll tell you exactly whose I did, because I'll have that in here right
Okay.
here.
Now, let me just make sure I still got this right. Your case never got out of the municipal court, correct? You never went to trial in the municipal court. You never got found guilty. You never filed an actual appeal of a conviction in the municipal court, correct?
Right.
Okay.
It wasn't a regular appeal. Yeah.
All right. So I just looked up the rules on petition for discretionary review. You want to know what the statement of what it is for says?
I have 2 documents here. It tells me exactly what it's for. Lisa McMahon's and Mark, what's his name? Mark, they have a whole, Mark Stevens, PDR requirements. And
Oh,
Lisa,
shit.
yeah.
Do not tell me you're using Mark Stevens bullshit.
No, actually, I used Lisa McMahon, but I had Mark Stevens in there also. But as far as I was looking at to make sure it complied with both of their, so Lisa McMahon, you know her?
I know who she is.
Okay,
Let me ask you this. You know that Steve is in California, not Texas, right?
I know he wrote it for Texas though, but still, yeah, I know. I realize that. That's why I found Lisa McMahon. So that I'm using hers as a guide.
Okay, listen carefully.
Okay.
The purpose of filing a petition for discretionary review is to ask the Texas Court of Criminal Appeals to review a decision made by one of the lower intermediate courts of appeals, not a trial court, like a municipal court.
It's talking about like the Fifth District, right?
It can be the county court at law, because if you'd have left the municipal court, the next place you would have gone would have been the county court at law. Since you were coming from a court of record, it would have gone to the county court at law, another court of record, as an actual appeal. You could have done it from that court and submitted a PDR, but you could not do it from the municipal court. You could have done it. Can I finish what I'm saying? You could have done it from the third court of appeals once you got out of the the county court at law, okay? But not from the trial court.
I didn't do it from the trial court. What are you talking about?
You have to have done it from the trial court when your case never got out of the fucking municipal court, Jane.
What I'm trying to say, okay, I'm not trying to get the CCA to make any kind of ruling in regards to what the municipal court did. Nothing at all has to do anything to do with the municipal court. I'm saying that I want them to review the actions of the Fifth District Court of Appeal, because they denied the habeas. I mean, the court below them denied the habeas appeal, and I wanted them to review that decision. All I wanted to
let's back up to that for a second.
Okay.
What did you get in writing in response to the denial of the habeas appeal?
That one I have in here. Let's see here. I don't memorize this shit.
You guys see how this goes when Jane comes to class?
But you asked me to come.
I did. and I wanted to understand the outcome. And so far, all we've haggled about is why you didn't like the outcome and why you need to get off that horse and go ride another one. But so far, I haven't got you to even see the other horse, much less put a saddle on it.
Okay, appellant's response to denial. Okay, it's right around here somewhere. Here's the order of dismissal, just to let you know.
Did they give you anything in addition to the order that says why?
Okay, you asked earlier about the order of dismissal from the municipal court. I'm going to tell you what it says since I'm seeing it right now. On this date, the court considered the state's motion to dismiss for want of prosecution. After considering the motion presented, the court is of the opinion that it should be granted. It is therefore ordered, adjudicated, decreed that the state's motion to dismiss the above cause is granted and the above cause is dismissed. That was the dismissal from the municipal court. Okay. On the denial of the habeas appeal, let me see, because she did write a little bit of stuff, but not very much because she's, let's see. So dismissal for want of prosecution, in other words, which means that they really didn't have a case to prosecute. And then what that means?
No, It means that the time has gone on so long and no movement in the case has been had, and they can't make a winning fucking argument no matter how hard they try, they quit. That's what that means.
Yeah. Okay. So then the County Court of Appeals number 1, the denial says the County Court of Appeals number 1, after reviewing petitioner's writ of habeas corpus rules, the petitioner writ is without merit. The writ is denied and the ruling was entered on blah, blah, blah. But I expected that from her. I knew that was going to happen. So, let's see what else.
Did she say why it was considered without merit?
No, that's all she said. And that's all she ever says, because that's the kind of court she's in. And that's the only thing she can do in that position. So,
and which court was that from?
The County Court of Criminal Appeals number 1. That was the court before the 5th District Court of Appeals, the one where I filed the habeas in. And the habeas was not as convincing as what the appeal brief was in any stretch of the imagination. But the appeal brief...
Well, I'd have to see what you argued in your habeas before I'd know whether or not there was any merit to it.
Well, the reason I say that, because I mixed as applied, I think, and a little bit into the facial. Okay. I shouldn't have done.
Well, in any case, the outcome, as we understand it at this point, is they dismissed the case for failure to prosecute. Okay? Failure to prosecute meaning that they don't have a winning case. They don't have any actual evidence that would support anything. They don't have any witness that can't be shredded on what they did or didn't see because they didn't see jack shit and they just made shit up as they went along, et cetera, et cetera, et cetera. In other words, they know they can't win this case if they ever got you to trial because you filed enough paperwork proving you understand the case well enough that they can't make an argument you don't know how to beat up.
I guess.
So, in order to stop wasting money having to go to court and refile this and refile that and answer these and answer those, they quit. That means you won. Now, they still got 8 months to refile it if they want to, but odds are, if they gave up once, you could force them to give up again, and they damn well know it. So odds that they're going to bring it to prosecute don't exist. Okay?
They're not going to prosecute it again, and I'll tell you.
Well, here's why I say that. If you actually intend to sue them for malicious prosecution and address the constitutionality, the unconstitutionality of the ordinance, by filing a civil suit in that regard, they can attempt to short circuit your suit by refiling the case if it's still within the statute of limitations of 2 years. Okay? Mm-hmm. They bring it back to kill your suit. Wow. Now, here's what you need to check on. What is the statute of limitations for filing your suit? Is it 6 months? Is it 1 year? Is it 2 years?
I think it's 2 years.
Don't think. Find out for sure.
Yeah.
Because it could very well be 6 months. And the problem there is they have 8. You understand where I'm going with this?
They won't bring the case back.
Stop and listen to me, Jane. Answer the question I asked you. Do you understand? No.
Yeah, I understand that.
That means if you file your suit within that 6 months to beat your deadline, they can refile. Now, the beauty of that is that stops the clock on your malicious prosecution and restarts it again in your favor. So let's say you wait 5.5 months to file your suit. Okay, you get it in below the deadline, and that triggers them to refile, thus nullifying your malicious prosecution suit. But because they refiled the same case to try again, they still only have 2.5 months to get you into court and find you guilty. Their clock doesn't stop. Yours does. So once they can't get you into court in that 2.5 months, and you run them into the ground again by refiling all the same shit we filed in the first one, they're still going to wind up null prosing this.
They will. They're going to lose.
Therefore, you go right back to a full 6 months to sue them a second time. Now you've got 2 claims of malicious prosecution. You understand?
I understand, but you think they're really going to do that? They're going to
Jane, I don't put anything past them based on what they've already shown they're willing to do and how long they're willing to do it.
Well,
because rule number 1 is they have more time and money than you do, and they know it.
Well, do you know the case that I revoked? The one that I revoked?
I don't care.
They dropped that one.
Again, I'm trying to get you to understand what is possible. I'm not saying they will or they won't. I'm trying to get you to understand what is possible. And you better always err on the side of caution that they will do it no matter what. If they don't do it, great. If they do it, you've expected it, you've prepared for it, and you're ready. And you deal with it, okay?
Mm-hmm.
So even if you hope and pray and think they won't do it, prepare yourself as if they will do it anyway. Keep your ducks in an orderly fashion and have them ready to march to war if they do it. That's all. You've already got the written paperwork. You've got everything you need. The only thing you may need to change is the name of the prosecutor, the date and time, and the case number. And everything else is already there, okay? So it ain't like it's going to be nearly as much work the second time as it was the first time. In the meantime, start writing your malicious prosecution lawsuit.
I already have, but I wasn't going to go that angle, though.
And why?
Oh, because malicious...
Why would you sit and write it if you're not going to do it?
I wasn't going to go that angle with a malicious. I was going to go civil rights claim.
Malicious prosecution is a civil rights claim, Jane.
Well, I mean,
you can make all of your other claims. Malicious prosecution is but one claim in your civil rights claim. Okay. Usually it's the only one you have. But now you would have any other constitutional rights violation they have, if they have any. However, the other benefit of this malicious prosecution suit is you can raise your facial challenge to the ordinance in the same fucking suit.
Okay. All right.
Okay? That's all I wanted you to understand out of this. We didn't have to go this hard this long if you'd let me get to this point just by just answering my questions. But the fact of the matter is, what I tried to get you to understand is why the appeals courts are saying we're not doing anything with this. Okay? And it doesn't matter because it left you the perfect out to do exactly what you wanted to do in the first place. Challenge the ordinance. And now you get to do it in a way that nobody but you controls. That's the part you need to let sink in. The ball is now in your court and you can volley it back in the best way that suits and helps you.
Well, you know, the other case that I had, they dropped that one too. I found
what other case?
The other case that they had that I revoked to get this case. They dropped it. They dismissed it.
Okay.
They dismissed it a year ago. Didn't even know that it happened. The reason why I got this case was being revoked. I mean, I revoked the other one. Remember? They did it on the last day of the probation for the other case. And on the first cat feeding case. But now here's the kicker. There's 10 cats over here now. There's not more than 10, but there's 10.
You know why they would have done that, right? Do you fully comprehend why they would have gone back on a case you've already been convicted of and dismiss it?
Because I took deferred?
No.
What?
They're trying to take away your constitutional challenge to the ordinance on an adjudicated case because remember, jurisdiction, subject matter jurisdiction can be challenged at any time.
Right.
Okay? And you could have made a subject matter jurisdiction claim due to the unconstitutionality of the ordinance. So if they dismiss that case too, that takes away that claim of challenging it on those grounds.
So if that's the case, then how does anybody challenge the constitutionality of somebody writing the ordinance or
exactly the way I just told you. You file suit to do it. You either get to see the criminal case through to the end to do it, or you get to do a civil action to do it after the fact. So, assuming you win.
A civil court is not going to rule on the constitutionality of an ordinance, are they?
Yes, they are. That's their whole fucking job. It's a civil suit when you're challenging the constitutionality of an ordinance. Okay. What you have to have is standing to make the challenge. Right now, you have it.
Yeah. Well, if I have 2 years to bring it, then I don't have to even bring it.
Well, again, don't assume that. Find out for sure what your statute of limitations are, because they vary greatly depending upon the type of claim.
Okay.
All right. Everybody in class entertained tonight?
Here's the thing also too about the appeals court, that the Texas Court of Criminal Appeals. You know, they have the staff attorneys who review every PDR that comes in there, and then they make a case whether or not, you know, and they circulate it around the judge if they want to. You know what I'm saying? Right. So it might not have ever even gotten in front of one of those judges, you know. They probably just
agree. Yeah, their law clerks would have weeded out the ones they didn't think the justices would have any reason to want to hear. Now, there's another possibility for them denying it. There's already a case on point out there that resolves the issue you're talking about.
But there's not. There absolutely is not.
Again,
it's probably the reason I think they did it is because they don't have enough people challenging ordinances, and that, I mean, out of municipal courts. There's not enough people appealing out and then taking it to that level. And so since they don't have that many reoccurring issues facing, you know, the same questions that I'm asking, because people just don't fight, then why would they address it?
Okay,
you know?
Jane, that goes to exactly what I'm talking about, the reason why they dismissed the first case as well as the second case. Okay? That would have made what you're doing an appeal, an actual literal appeal, rather than a civil suit. Okay? They're hoping you don't understand the difference and that you do it wrong to the point where your statute of limitations goes away because you didn't understand the process. So what I'm trying to tell you is that when did you said they dismissed the other case against you a year ago?
Yeah.
Okay, well, here's the thing. If your statute of limitations actually is 2 years, you would now have two claims of malicious prosecution, the original case and the case that just got dismissed, because both of them were resolved in your favor. Even if it was after the fact, it resolved in your favor, and now you have a malicious prosecution claim for it, as long as you're within the statute of limitations. So you could very well get up to 3 if they refile this case after you file the second one.
Matter of fact, it's strange what they did, because they dismissed it before I think they found out that I got a new case.
Well, in any case, check the statute of limitations. They can't stop what they do in that case. You file malicious prosecution in that case and a constitutional challenge to the ordinance in that original case and take them to court over it, because that one was definitely resolved in your favor and they can never, ever bring it back again or reinstate it.
Too late now, yeah.
Okay, so that one is a dead bang conclusion as long as you're still within the statute of limitations.
Right.
Okay, so that leaves the case they just dismissed and the possibility of turning it into 2 malicious prosecutions.
Right.
Okay?
Okay.
So if I were you, that's what I would focus on doing, and I would pursue it, because the only way you're going to make them stop is to not only get a ruling on the constitutionality, but hit them in the fucking wallet where it hurts.
Well, I hope that's what happens.
Well, if you do your suit properly and you make the allegations and cite your authorities properly, there's no reason why it shouldn't, because Texas legislature made it very, very clear that they were giving relief to people who were being maliciously prosecuted when they created the act to allow it to happen.
But now here's the thing, though they do not look at level of offenses and as far as...
No, they do not. The level has nothing to do with it. If the defense wins for any reason and in any manner, whether it's dismissed with or without prejudice, it's overturned on appeal, if the case is eventually at any point resolved in their favor, they have a claim for malicious prosecution.
Okay.
That's all the law requires. The only question is, what is the statute of limitations on making that claim?
Okay.
All right. Anybody else have any questions or commentary on what we've discussed about Jane's case and the outcome of it? And I'm sorry it wasn't as much new stuff as we were hoping to get into. I didn't expect this discussion to take as long as it has, but again, this is usually how it works when Jane comes to class. But at any point, this is why you have to pay attention to what you're reading, what you're citing, and how they actually work. And never, ever try to use a court case out of the context in which that court case was decided.
I sent you.
Stop.
I sent you the whole PDR.
Okay, great. You sent it in an email, I hope, right?
Oh, it's in the chat.
Why
the
do you give
PDR is
me
in the
shit?
chat.
Why do you give me stuff in the chat, Jane?
You don't see it?
I see it.
Okay, good.
I'm just trying to get it here.
After you see the whole thing, maybe you'll understand where I'm coming from.
I doubt it, but I'll check.
You try. Because it's including my appeal brief is in it. No, wait. Is the appeal brief in there? I think my response to the denial of the appeal brief, I can't, because they got the PDR, the appeal brief actually got sent from the 5th District to the other court initially because they wanted to have everything in case it was granted, but they still didn't review it. Did you get my appeal brief? I sent it to you before, right?
I don't know.
Because I don't know if it's in this document right here. Everything else is pretty much, but I don't think the appeal brief is.
Well, then send it to me through email, not through chat.
Okay.
Okay. All right. That said, again, I'll ask again. Anybody got anything they want to say or question or any other separate issue they need to bring up before we get out of here tonight? Because we are well past quitting time.
I've got a question related to the past hour we spent here, and that's relative to the habeas. So if you've got a trial going on, I thought habeas was just you're in jail and you're trying to get out of jail.
No, habeas is any type of confinement relief. That confinement can encompass so many things, including binding you over for prosecution.
Okay, so would that be applicable to Helen and or my case, given the way that the judges have been acting in them?
Had you filed speedy trial briefs, yeah.
Okay.
The problem is when you don't file a motion for speedy trial, then you are saying however long this takes, it takes, and I don't care about my speedy trial.
Okay.
And your speedy trial clock does not start until that motion has been made.
So we can file that at this point if we haven't already.
You can, but then whatever the clock for speedy trial is doesn't start ticking down until that point.
Okay.
But on the habeas, though, you can file it now also, too, and not go to trial if that's what you're trying to do. But you have to have a good reason to file it.
Well, in my case, if they're already ignoring everything that I'm sending in motion-wise and all that, why go to trial with it?
Well, you got to remember that the habeas is not going to apply to civil suits. It's going to apply to criminal suits. It's not going, or criminal cases. It's not going to apply to civil cases.
Right. Well, it's being tried under criminal code, so it's technically it is still a criminal case.
Right. But again, you've got to be careful on how it works.
Okay.
So
but is it unconstitutional what they're charging you with?
Well, what's unconstitutional about it, in my opinion, is the fact that they're trying to try me in a district court which has no access to jury trial, and the state and federal constitutions say I have a right to jury trial.
Well, so, you can challenge the constitutionality of the statute, ordinance, or court rule they're using that violates the state constitution in a habeas proceeding. That you can do.
Okay.
Because if you negate what they're using as the authority to give that court jurisdiction in the way they're doing it, see, they may very well have subject matter jurisdiction because the legislature said they did.
Yeah.
That does not free them up, and the legislature cannot enact a law, and the judiciary cannot create a judicial rule of procedure that allows them to violate the state constitution. So you can raise a constitutional challenge to whatever authority they're claiming allows them to proceed without a jury.
Okay, so I got to figure out what they're using to try to proceed without a jury, and then I raise a habeas.
Yeah, they're either going to have to cite some sort of court rule, court case, or law that says they don't have to provide you with a jury trial.
And how do I get them to do that, to provide me with that information? What a motion for it, a hearing,
Well, you can file an interlocutory appeal to a higher court, or you can file a habeas stating that there can be no authority for this court to try this case absent a impanel jury and make a habeas challenge making that argument. I am being denied unconstitutionally denied, or I am being denied my constitutional right to a trial by jury without any cited authority granting such a power by this court in this area, whatever the court is, and I wish to make a habeas challenge in that regard.
Is that a different state?
Yeah, I'm in Arkansas.
Yeah, Arkansas.
Well, that's not too much different from Texas, is it?
Every state's different enough.
Yeah. So I'll look into that, and then maybe next class we can cover just a little bit about habeas.
Well, next class we can cover what it is you find out about what they're using and how we can use the habeas to go after it.
Okay.
I don't know if it's a habeas, so hang on 1 second, because there's a thing that shows the different writs and what they're used for and what only they can be used for. And let me find it right quick.
Didn't you use it?
If we're challenging the constitutionality of the prosecution, because of the way the court is dealing with the prosecution using an unconstitutional methodology and or procedure, then the habeas should be fine because they're binding him over for prosecution in a court that cannot have jurisdiction the way it's operating.
Yep.
Okay.
And even in civil, Eddie, for that matter, in the state constitution for Arkansas, it says all matters at law. And then separately under criminal in the Constitution, it says all criminal trials. So it does cover it for civil as well. And you could waive it, but I've absolutely refused to waive it, and I've put that in.
And you can waive it in a criminal case. But if you haven't waived it, they can't just deny it because they want to.
Exactly. And so that's where I want to challenge the constitutionality of this court even being able to hear this case in the first place.
Well, when you said they don't have to give you a jury trial, I thought for sure you had seen something in writing that said that.
No. They flat out, they have said that it's not
If
required.
they've said it, then you have the right to petition the court to disclose the authority upon which they're relying to make that assertion.
Okay.
Look at the chat. Look at the chat. There's a comparison.
Motion for clarification or?
No, it's a motion to state authority.
Motion to state authority.
You can title it whatever you want. That's what I would call it.
Okay.
But look in the chat. I don't know your name. What is your name?
James.
Oh, James. Look in the chat because there's a comparison of the different writs.
Of extraordinary writs.
Okay.
That you can use and what the purpose is of, and also too, if they, it talks about the jurisdiction or nature of the injury address, the timing, the waiver concerns, all that stuff.
Okay. Thank you, Jane. I appreciate it.
All right. Anybody got anything else?
Thank you, Eddie. I appreciate it.
Yes, sir. No problem.
I'm gonna send you.
All right, guys. Again, if you haven't paid your dues for the class, please do that. If you've got somebody that wants to join, please get them. And I hate to sound like a broken record, but I couldn't get any poorer if you frickin' dug a hole and buried me in it. So if I'm helping you with a case or something and you've got a little spare money to donate, please feel free to do that because I am not even treading water at this point. I'm getting drugged down. There ain't a damn thing I can do about it.
I thought you had a lawsuit going.
I got 2 lawsuits and now possibly 3, but till I get paid, that don't mean nothing.
Oh.
In the meantime, I got bills going out and no money coming in because I got broken ribs and can't freaking work.
Wow. I didn't hear that story.
Well, this is the second time they've been broken under 2 different instances.
Having to do with dogs?
No, the second one has to do with this damned house I'm living in trying to murder me every other week.
Oh, damn. So when you gonna upload this video tonight? Because I didn't get to hear that.
Yeah, it'll take about an hour for it to encode and then it'll be uploaded. It'll be in the free folder as well as the actual class folder.
Okay, cool. What about Helen's case? Is hers going forward or what?
She doesn't go back in again until the 15th. In the meantime, she's been doing what we've talked about, going through the motions and getting her pleadings done. So hopefully she's learning as she goes well enough to do the things she's got to do. We got to give her a few practice sessions, though, to make it work out.
And Tim's not coming back or what?
Tim may not come back for a while because he's financially at odds right now with all he's going through.
Yeah.
What happened to Chris? I hadn't seen him for a while.
I don't know. I hadn't seen him either, and I hadn't gotten an email saying why.
What happened to Kevin?
I don't know that either.
No, what was it about the Asian guy?
That is who she's talking about.
Oh, okay. Wow.
Okay, anything else? All right, guys. Again, anything you can provide donation-wise is greatly appreciated. I really could use it if you got it, but if you don't, that's fine too. I just thought I'd let y'all know because I am where I am and ain't a damn thing I can do about it at this point. But in any case, take care of yourselves. Have a great weekend, and I will see you on next week's class.
Thank you.